Evicting a tenant can seem like a complicated process, but in this video we'll quickly explain the eviction laws in California and outline some simple steps landlords can take to initiate an eviction. We're eForms, the largest online database of fillable legal documents. In this video, we'll talk about what an eviction process looks like, California laws that determine how evictions are handled, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. First, what is an eviction? Eviction is the process of legally removing a tenant. Even if a tenant has done something wrong, it's illegal for a landlord to change locks on a property or physically remove a tenant from that property. This is often known as a self-help eviction. If a tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. An eviction is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. In California, if a tenant breaches the terms of a lease, a landlord can serve what's known as a notice to quit. There are 6 documents that fall under this umbrella, and each applies to a different circumstance. The first is a 3-day notice to quit for non-payment of rent. If the tenant is overdue on rent by the number of days specified in the lease agreement, the landlord can issue this notice, which gives the tenant 3 days to vacate. The next is a 3-day notice to quit for a curable breach. What this means is that the tenant has breached the lease in some way not related to rent payment and is essentially fixable. An example of a curable breach is having a pet that's not allowed on the property. This notice orders the tenant to either fix the problem in 3 days or leave. There's also a form called a 3-day notice to quit for an incurable breach. This means the problem cannot be fixed. An example is a tenant getting caught selling drugs on the property. This notice tells the tenant to leave within 3 days. Another option is a 14-day notice to quit that can be used by victims of domestic violence. Unlike other types of notices, this one is typically given by a tenant to a landlord. If someone is being stalked or abused, he or she can use this notice to terminate the lease with just 14 days notice, regardless of what provisions are in the lease agreement. A 30-day notice to quit is given to tenants on month-to-month leases. This form lets tenants know their lease is being terminated in 30 days. If the tenant has been on the property for more than a year, the landlord must use a 60-day notice to quit. If the tenant fails to respond appropriately to a notice to quit, the landlord can file for an eviction in the court in the county where the property is located. This is done through the filing of a combination of 3 forms. The first is a 4-page form known as the complaint. The second is the cover sheet, which basically just asks what kind of civil case is being filed. The third is the summons or form SUM 130. This informs the tenant that an action is being brought against him or her. The tenant must be served copies of the documents. This can be done via certified mail or a civil process server. The server must fill out a proof of service form and give it to the landlord, who will then file it with the court. This serves as proof that the documents have been delivered to the tenant. If the notice was mailed, the tenant has 15 days to respond. If it was delivered in person, the tenant has 5 days to respond. The tenant can respond by filing what's known as an answer, or Form UD 105. The landlord has to wait for the court to provide notice of whether the tenant has filed the answer. If the tenant doesn't respond, the landlord can ask for a judgment from the court. This is done through the filing of 3 forms that authorize an eviction. This first one is known as the Request for Entry and Default Judgment, or Form CIV 100. The second is a judgment for unlawful detainer, and the third is a writ of possession. Once the court approves the writ of possession, the landlord can deliver a copy to the local county sheriff's office. This form authorizes a sheriff or constable to remove the tenant and his or her possessions from the property. From eviction notices to court documents, we've got everything you need to get an eviction proceeding going in California. Access it all at the link below. And don't forget to subscribe for more videos about important legal issues.